So you may have heard the terms provisional patent application and non-provisional patent application. But what these patent applications are and how they fit into the patent process is not always entirely clear. So what this video is going to do, it's going to give you the full rundown of the two ways that you can start the patent process. That being by first filing a non-provisional patent application or by first filing a provisional patent application. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney and author, and I help clients of all sizes protect their ideas and inventions, from Fortune 100 companies to successful startups to Shark Tank winners. You may also be familiar with my best-selling book, Patents Demystified, which is used worldwide by inventors, entrepreneurs, and startups, and used in top universities like Harvard, Stanford, and MIT. Also, be sure to subscribe to the channel for more great information about patents and startups, and hit that little bell icon so that you can get notifications of when new videos come out. All right, so let's jump right into it. All right, so the two ways that you can start the patent process. Like I said, you can start with filing a provisional patent application or by filing a non-provisional patent application. So let's start by talking about the non-provisional patent application. Now, the non-provisional patent application is the more formal application. It's filed at the United States Patent and Trademark Office, USPTO, and it just sits in line. It waits for about 3 years before examination begins. And yes, I know that's a long time. It's the US government. They have a huge backlog. So you're just waiting in line for 1 to 3 years before examination begins on your application. And when it does, what the patent examiner assigned to the case is going to do is going to, one, make sure that it satisfies the basic formalities of a patent application. But more importantly and substantively, the patent examiner is going to do a prior art search and is going to determine whether the invention as claimed is new and non-obvious compared to the prior art. All right, so this negotiation with the examiner continues. You will file a response where you can amend the application. You can argue against the rejections, which is going to happen about, I'd say, 95% of the cases you're going to see rejections. Okay, so you can go back and forth with the examiner, and hopefully at some point the examiner is convinced that the invention as claimed is new and non-obvious compared to the prior art that's already out there, and the application will then issue as a patent. So that's the first way that you can start the patent process. The other way is by first filing a provisional patent application. Now, the provisional patent application, it's just a placeholder. It establishes a filing date, and it only lasts for 1 year. It automatically expires after 1 year. That term cannot be extended. Only lasts for 1 year. And at the end of that year, to maintain the priority that you established with the provisional filing date, you have to then file a non-provisional patent application. So, like I said, the provisional just sits there. It's not examined at all. It just establishes a priority date. Now, one of the things that's important to note about provisional applications is that the USPTO is going to accept really any document that you file. I mean, we could print out a piece of paper and write some scribbles on it, file it as a provisional patent application, and the USPTO is going to give us a filing date, right? Sure, you know, that's great and all, but that's going to be effectively worthless. So one of the things to keep in mind with provisional patent applications as starting off the patent process is you only get credit for what you actually file. They're a lot less formal than the non-provisional patent application, which has to have a very specific structure, be formatted in a certain kind of way. Otherwise, it's going to be rejected. The provisional doesn't have all those formatting requirements and can be very informal, which can be a huge benefit in a lot of ways because the provisional patent application can be more cost effective. You don't have to have things quite as formalized. Another great benefit of the provisional patent application, and the reason why I recommend it almost universally to startups, is because it gives you a lot of flexibility. And here's what I typically recommend with most startups. File a provisional patent application, which again lasts 1 year before you have to file the non-provisional patent application. And during that year, you're patent pending just as much as you would be with a non-provisional patent application. And during that year, if there's changes and if there's updates, which tends to happen with startups, I've seen times where the invention completely changes. It looks nothing like it did at the beginning of that year. So, you know, as the invention changes, you can file updates to that provisional patent application, which essentially is just adding things to it and filing a new provisional. Or what you can do is at the year anniversary when you have to file the non-provisional patent application, then you can add updates there. So it gives you a lot more flexibility. In contrast, if you file the non-provisional first, if you make any changes to the invention, you can't add those things. You know, that application is set in stone. If you wanted to protect those new things, you'd have to file a full new non-provisional patent application, which is going to be really costly and doesn't make a lot of sense. And you're also still then going to be incurring the additional cost of 2 patents being examined. So the provisional application gives you substantially more flexibility. Gives you a year to kind of test the market. The provisional can be a lot more inexpensive, and you know you have so much more flexibility with the provisional application. So again, 2 ways that you can start the patent process. Start with the non-provisional application. Goes to examination, hopefully that issues as the patent. Second way, file the provisional patent application. It lasts 1 year. File the non-provisional, and then the application process continues the same. So, you know, again, it goes through examination, and hopefully it survives, and you get an issued patent.